Thank you for coming by. This is American Project. Please be sure to like the video, and if you enjoy my videos, please subscribe. Trump request to appeal Fani Willis disqualification has been granted. Fulton County Superior Court Judge Scott McAfee has granted former President Donald Trump's request for a certificate of immediate review, allowing the former president and 7 co-defendants to appeal the judge's order denying a disqualification of Fulton County District Attorney Fani Willis. The certificate of immediate review, filed on March 20th at the Superior Court of Fulton County, State of Georgia, allows President Trump and 7 co-defendants to seek an appeal from the Georgia Court of Appeals, which has the discretion to accept or decline to hear the case. Judge McAfee has issued a certificate of immediate review, allowing us to take our motion to disqualify Fani Willis directly to the Georgia Court of Appeals. David Schaefer, former chairman of the Georgia Republican Party and one of the 7 co-defendants, said. Besides Mr. Schaefer, the co-defendants who can appeal the judge's disqualification ruling are Rudy Giuliani, Mark Meadows, Robert Cheeley, Michael Roman, Harrison Floyd, and Kathleen Latham. All of them had joined the initial motion to disqualify Ms. Willis and later joined a motion for a certificate of immediate review. The request for immediate review, filed on March 18th by Steve Sadow, attorney to President Trump, stems from Judge McAfee's decision to allow Ms. Willis to remain on a high-profile case in which the former president is accused of election interference. President Trump has denied wrongdoing and has called the case a politically motivated witch hunt meant to undermine his 2024 comeback bid for the White House. Ms. Willis was accused of engaging in an improper romantic relationship with prosecutor Nathan Wade and benefiting from it financially. The two acknowledged the relationship but denied any financial benefit or conflict of interest. Now, they denied having the relationship until after they had the case, but there's witnesses that say otherwise, so that's a big fight about this here. Judge McAfee said in a March 15th order that there was an appearance of impropriety, but no conflict of interest had been proven, which a lot of lawyers have been looking at this case and they do not agree with him. He found that disqualifying Ms. Willis wouldn't be the appropriate remedy for the appearance of impropriety and instead ordered Mr. Wade off the case. Mr. Wade resigned hours after the morning order was issued. All right, now, I believe Ms. Willis and Mr. Wade discussed that, and he decided to get off the case, and then the paperwork was put through. So, in early testimony, Mr. Wade had acknowledged a romantic relationship with Ms. Willis, but testified that it had ended before the election case indictment was handed up. All right? That's not quite correct. Actually, they said they didn't have a relationship until after it was already done. Judge McAfee noted that Mr. Wade's inconsistent answers under oath in his recent divorce case showed a willingness to conceal his relationship with Ms. Willis, and had opined that an odor of mendacity lingered on a prosecution team with Ms. Willis's and Mr. Wade's testimonies in his court. And indeed it did. There's a divorce case going on with Nathan Wade, and the lawyer over there was asking questions, and he was sidestepping it and everything else and hiding his income and all kinds of things. His wife of 26 years just wanted her, part of the money that she's entitled to because she was a wife for 26 years and she worked at the house and raised her kids and all. So, and he was not leaving any money for the house and the necessary needs. Anyway, he ended up having to in the end. The case still has 15 defendants, 4 have accepted plea bargains, and is expected to run for about 6 months. Okay, now Judge McAfee had a 10-day window to decide whether he would allow a review of his disqualification decision. By allowing review, pretrial proceedings could technically be halted for up to 45 days while an appeals court decides whether to take the case. However, in his March 20th certificate of immediate review, Judge McAfee said that the court intends to continue addressing the many other unrelated pending pretrial motions, regardless of whether the petition is granted within 45 days of filing, and even if any subsequent appeal is expedited by the appellate court. Okay, well, I've been keeping an eye on this case, and I will continue to do so, and I thank you for coming by. There you have it. I appreciate it. Have a great day. God bless.